Hello, welcome once again to Leto's Law. I'm Steve Leto. Important case in front of the Supreme Court right now. Story is sent to me by several people. Thank you very much. And this is the story as reported in Forbes magazine, but it's been reported elsewhere. The Supreme Court traffic stop case could drastically limit drivers' Fourth Amendment rights. And the article is written by Nick Sabilla, and the case is called Kansas versus Glover. But the U.S. Supreme Court will decide whether or not police have reasonable suspicion to pull over a car for no other reason than that it's owned by somebody with a revoked driver's license. And that's a decision that could have major ramifications for the Fourth Amendment across America. Today, about 11 million drivers in more than 40 states have had their licenses suspended simply because they have unpaid court debts. This is from the Freedom to Drive Coalition. That's a group of over 100 different organizations. Several of the members of that group, including the Fines and Fees Justice Center, the Institute for Justice, and the Southern Poverty Law Center, have all filed an amicus brief with the Supreme Court asking them to declare these stops unconstitutional. So Kansas and Glover are the two litigants. Of course, the Kansas is the state, not the band. And Glover is a person, presumably, who was pulled over because he had a revoked driver's license. And the question is, if a cop is driving along, runs the plate in a car, and it comes back and says, well, the owner of that car has got a revoked driver's license, can the police officer then simply pull that car over for that reason and that reason alone? According to the brief, permitting police officers to conduct suspicionless seizures of vehicles registered to owners of suspended licenses without knowing who is actually driving will invade the Fourth Amendment rights of millions of Americans with little to no corresponding benefit to public safety. That, again, is according to the brief filed by that group. And now there are things out there called automated license plate readers that police cars can get, and they can capture thousands of plates per minute, depending on where they're located. And they're becoming increasingly more common. ALPRs have already recorded the license plates of cars parked near mosques, gun shows, and political rallies. And with this technology, and the Supreme Court's also said this stuff's okay, states could easily open a Pandora's box of revenue drive policing practices like flagging and stopping individuals without standing court debt. They also wrote and said, just because your driver's license is suspended doesn't mean someone else can't use your car to drive you to work, drive your children to school, or drive an elderly parent to a medical appointment. And if your spouse, a friend, or a relative drives your car, they risk getting stopped. Now, this case started back in April 2016 when Douglas County Sheriff's Deputy Mark Mehrer saw a 1995 Chevy pickup truck drive by. Mehrer ran the license plate and learned that the truck was registered and owned by Charles Glover Jr., who had a revoked license. Now, we do not know why his license was revoked. That's not in the story, nor is it in the apparently in the case. Mehrer didn't see any traffic violations and couldn't identify the driver, but he assumed that Glover was the one driving and decided to pull the car over anyway. As it turned out, Glover was the driver, so he was promptly charged with driving as a habitual violator. Glover filed a motion to suppress the evidence from the stop, arguing that it violated his Fourth Amendment rights. In July of 2018, the Kansas Supreme Court unanimously sided with Glover, ruling that Mehrer had no information to support the assumption that the owner was the driver. That was a hunch, unsupported by particularized and objective belief. A court cannot engage in judicial gap filling based on a lack of evidence, a justice there wrote. And we've talked about this before. When the police say they have a hunch about something, that's not a reason. A hunch is not a reason. Presuming that the owner is the driver is invalid because the state no longer has to prove the officer had particular and individualized suspicion that the registered owner was driving the vehicle. That presumption impermissibly relieves the state of its burden of proof and shifts the burden to the driver. After all, families may have several drivers sharing vehicles legally registered in the names of only one or two of the family members. And as they pointed out, a person with a revoked driver's license commits no crime by simply owning and registering a vehicle. Nor does that person commit a crime by allowing another licensed driver to use a registered vehicle. Nor does the state's ruling prevent police from pulling drivers over if they're speeding, swerving into traffic, or otherwise caught breaking the law. And again, the Fourth Amendment protects you from unreasonable searches and seizures. And the question is, what would be the reason for pulling over a vehicle simply because it is registered to somebody who is a revoked license? That has nothing to do with who might be driving the vehicle. Now, we all know that the odds are that some of these vehicles are being driven by the people with the revoked licenses to whom they are registered. I've mentioned that before. I did a whole video on this, how police will pull somebody over, take them to court, their license gets revoked. They get picked up on driving a revoked license. A judge will actually tell them, I find you guilty of this, fined and all that. License is still revoked. Person walks outside, gets in their car and drives home on the revoked license. Happens all the time. Doesn't make it right, but it happens all the time. So that's what the police are getting at is, look, we know a lot of these are that situation. But the question is, just because some of this is happening, does that make everyone who's registered a vehicle while having a revoked license, does that mean that there's a carte blanche to pull these vehicles over? The state of Kansas appealed the decision of the U.S. Supreme Court, which agreed to hear the case this past spring. Oral argument is slated for November. Stops like the one at issue here are both reasonable and serve important public safety interests, the Kansas Attorney General argued in its brief, while those stops would impose only a minimal intrusion on the drivers themselves. Well, I'm not sure how minimal the intrusion is to get pulled over by a police officer and go through the rigmarole of, driver's license, registration, proof of insurance. Cop goes back, runs all your stuff. Meanwhile, you've got someplace to be. It's not minimal intrusion. Rallying behind the state, the U.S. Department of Justice, 17 state attorneys general, and several law enforcement groups have all penned briefs that largely echo Kansas's arguments. The National Fraternal Order of Police claimed the Kansas Supreme Court decision jeopardizes police officer and public safety. Separately, the National District Attorney Association argued that the ruling threatens Kansas's interest in prosecuting wrongdoing and even claimed that license suspension or revocation are not penalties for the casual traffic infraction. Actually, they are. So what happens is people get a minor traffic offense, they don't pay the ticket, and their license gets revoked. That happens in many states. Contrary to law enforcement's claims, many licenses have been suspended with scant connection to public safety. One study showed that more than 100,000 Kansans had their driver's license suspended for not paying traffic tickets, which amounted to about one suspended license for every 20 adults living in Kansas. In Ohio, nearly two-thirds of all license suspensions weren't actually related to driving, while unpaid parking tickets accounted for more than half of Wisconsin's suspended licenses. So there you go. One 2006 study reported that less than 6% of all suspended drivers in New Jersey were suspended for purely driving-related reasons. That same study further revealed that 42% of affected drivers lost their jobs after their licenses were suspended, while almost half of the drivers thrown out of work could not find another job. Moreover, 8 states automatically suspend driver's licenses for drug crimes unrelated to driving. Before New York and Pennsylvania repealed their suspension statutes earlier this year, the 2 states collectively prevented nearly 330,000 people from driving due to drug convictions. South Dakota's blocked almost 1,000 residents from obtaining a driver's license because they defaulted on their student loans. And in Duval County, Florida, which includes Jacksonville, unpaid tickets for minor pedestrian offenses, including jaywalking, resulted in nearly 1,000 people losing their driver's licenses. So again, no connection to driving offenses, no connection to even driving. You're out walking around, you get a ticket. Without a driver's license, many Americans can't get to work. It should come as no surprise then that license suspensions all too often trap drivers in a vicious cycle of debt. And as a result, these suspensions are concentrated in poor communities and disproportionately in communities of color. And since these communities have fewer cars per household, that makes drivers more likely to borrow vehicles from friends or family members and more likely to get pulled over should the Supreme Court side with Kansas. So this is going to go back and forth, obviously, as we argue about it. And eventually, the Supreme Court's going to hear arguments in November and make a ruling somewhere down the road. But again, the question is, you have a suspended license, but you own a car, it's legally registered, etc. That car is driving down the road with somebody behind the wheel. The police see the car, run the plate, and go, oh, it's registered to somebody with a suspended license. Let's pull it over. And the question is, can they do that? And the Supreme Court is going to rule on that because as of right now, Kansas had said it was impermissible under the Constitution, but the U.S. Supreme Court gets the final say. So Nick Sabilla wrote the article. It's in Forbes magazine and online. It's a great article. It's a great explanation of the issues at hand, and we'll see what happens. As soon as I hear about it more, I will update you. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.